who would like to begin?
Well, I guess I was sort of two minds about how to handle this morning. I have a whole presentation of all of our case, the full, everything, full 9 yards. But you did ask some fairly pointed questions, and I wasn't sure whether you wanted to just jump to those or whether we should go through the whole thing.
Why don't you jump to the key questions I think that the board has.
Okay.
That'll help. And then I think what may happen as a result is some of your other issues may arise as we go through those questions.
Okay, that sounds excellent. So your first question had to do with the two sections. These are all of this stuff is from Streets and Highways Code. Section 2704.04, subdivision A, and the other section being 2704.06. And you comment that both provide descriptions of the high-speed rail system upon which Prop 1A bond funds can be expended. And your question was, does the blended system proposed for the San Francisco Peninsula and mandated by SB 557 violate either of these sections such that high-speed rail project cannot qualify for Proposition 1A funding? So let me start by saying a little bit about, let me sort of back up a second, a word about Prop 1A, which of course was a measure put on the ballot by the legislature, providing essentially $10 billion for the high-speed rail system and other associated capital projects. I think the point I want to make is it went beyond just providing authorizing bonds and restricting how they could be used, because Section 2704.04A, which gives the intent of the legislature and, of course, of the voters, basically talks about a system to be built pursuant to this measure. And likewise, Section 2704.09, which is also going to be a very sort of important, I guess, bone of contention here, talks about the system to be built pursuant to this, what do we call it, the chapter, which of course the chapter being the chapter that was enacted by Prop 1A. So they both go beyond just the bond funds to talk about the project, the system that's being built. And the requirements that are set in those two parts are really requirements on the system, whereas other parts of Prop 1A are specific about talking about the bonds and the bond funds. So 2704.06 specifically says these are the uses to which the bond funds can be put. And there's an overlap between 2704.04A and 2704.06 in that they both talk about, because obviously if you're restricting what the system is, you can't use the bond funds for something that's not part of what's being authorized. And whereas 2704.06 is more specifically saying these are the things you can use the bond funds for. And both of them reference the 2005 and 2008 environmental impact reports. And both of them say this has got to be consistent with the 2005 and 2008 EIRs. But 2704.06 also talks about it's got to be consistent with those or with any additional environmental studies that the authority does on this project. And there's a reason for that difference. And the reason has to do with the purpose of those two sections. As I said, 2704.06 is defining the applicable or the authorized uses for the bond funds. 2704.04A is basically the legislature providing the general legislative intent behind the whole bond measure. And it's looking, as it were, at the whole system being done, and says, these are the general ways, and this is what this system has to do in general terms. And one of the things it says it's got to be consistent with the 2005 and 2008 EIRs. And you have to ask, why did it say that? And I think there were two reasons for that. One is to inform the voters about what it is they're authorizing. In other words, when it's telling the voters, here's what we want you to approve, and it's saying the legislature's intent is that this is going to build a system that's consistent with the 2005 and 2008 EIRs. It's essentially referring the voters to those two EIRs, saying, if you want to know what we're authorizing here, this is it. Look at these two EIRs, and you'll find out this is what you're authorizing. So if the voters, when they looked at the measure, were expecting this is what we're approving. We're approving what's in these two EIRs. And that's appropriate because those were both program EIRs. They, as it's usually described, those are the 30,000-foot view of the project, and saying, okay, here's in general what we're doing here. And that's what the voters needed to know in terms of saying, should we approve this or not, is what are we actually talking about here? Now, the 2704.06 is different because it's saying, here's how the bond funds are to be used. And one needs to remember that when this measure was written, the 2008 EIR had just been approved. It was approved on, I believe it was July 9th of 2008. And this was written over the time period between July and early August of 2008. So they knew that, okay, this has just come out. This is the last piece of the program level environmental review. The 2005 EIR had left out the Bay Area to Central Valley section, explicitly saying we're going to do a separate EIR on that. This filled in that missing piece, so the legislature could say, here's the whole project, here's the whole system that we're going to describe to the voters. But it was a program level. It didn't give you all the details. So if you ask about, for example, what stations are there going to be on the peninsula, that neither the 2005 nor 2008 ER are going to tell you, is there going to be stationed and if so, where? They both said, well, there's going to be one at Mill Drive, but there may also be one at Redwood City or possibly Palo Alto. Not sure which. That was left to the project level. Likewise, neither the 2008 EIR or even the 2010 or 2012 EIRs talked about what's going to be the vertical alignment of the project on the peninsula. Is it going to be elevated? Is it going to be surface level? Is it going to be depressed? They said, leave that to the project level. And likewise, other sections where really all there was a 2005 EIR, you really didn't know the details of the alignment. You didn't know where the stations exactly are going to be, and yet 2704.06 says this is what you can spend the bond funds on. Well, if you don't have a description of a station, how can you spend the bond funds on it? If you don't know what the station is, how can you spend the bond funds on it? So the 2704.06 said, and additional environmental studies, because it understood there's going to be project level review. That's going to fill in the details. And in terms of knowing what you can spend the bond funds on, you got to look at those too.
Don't you think that also reflects a understanding by the legislature that 270404 could also be modified?
No. And let me explain why. Because the 2704.04 is the legislative intent. It's saying this is what we're doing here. And it's telling the voters, we're building something, and you can look at these two EIRs to understand what you're approving. If you said, and any changes that are made after this, the voters really wouldn't know what they were doing. They would be buying a pig in a poke. And the legislature was very aware that this was a potentially controversial project. They wanted to give the voters confidence that they knew what they were getting. So when they said 2005 and 2008 EIRs, they said, you want to know in general terms what we're building, this is where you look, this is what we're building. And the expectation would be, if there's going to be changes to that, if you're going to go back and say, hey, wait a second, we're not going to do it that way, we're going to do something different, you should go back to the voters. Because the voters had an expectation that they were approving the project that was described in the 2005 and 2008 EIRs, not something that would be added later. So that's the reason why there's a difference between those two sections. That's the reason why one of them included the extra language about additional environmental studies, the other one did not. They had two different purposes. And again, legislative intent says or rather, one of the canons of statutory interpretation is if you've got two different pieces of language used in the same or closely related statutory sections, the presumption is they're intended to mean different things, and they are, and that's why. So,
I'm sorry.
that gets us back to the question, okay, so what about the blended system? Well, the blended system is not mentioned in the 2005 EIR, and it's not mentioned in the 2008 EIR. Actually, I have the slides there. There you go. So, the next few slides are from the 2005 and 2008 EIRs, and more specifically, they are showing what was in those EIRs about the high-speed rail system going up the peninsula. And go back to this first one. So this is, oops, too far. Okay. There. So this is showing 4 tracks. And you can see there are 2 central tracks, which is high-speed rail and Caltrain Express, and then there are 2 outside tracks for the Caltrain local and also for freight lines. So this is what the voters were told is going to be from the 2005 EIR. This is what it's going to look like up the peninsula. It's going to be 4 tracks, 2 for high-speed rail, 2 for local Caltrain service. And the other is, this is one showing a slightly elevated embankment, and this is showing on elevated depressed right-of-way. So this is what the voters expected to see in the 2005 EIR as what was going to be up in it, 4 tracks. This is the 2008 EIR. It's basically the same slides.
Do you think that's prescriptive as opposed to just simply an example?
Yes, and in fact there is also text in the EIR, in the 2008 EIR, that basically says, let me find it here. Here it is. It says, quote, "The alignment between San Francisco and San Jose is assumed to have 4 tracks." That's in the 2008 EIR.
Why do you think that makes it prescriptive, though?
Because it's basically saying this is what we're expecting to do here. We're going to have 4 tracks. And if you look at the analysis about, well, how is this going to work? Even the schedules all show that they were sort of example possible schedules, and they all show them running on separate tracks. In other words, there's no reason they don't have to coordinate between the Caltrain and high-speed rail schedules because they're not running on the same tracks as the Caltrain trains. So it's all expected. The expectation of, admittedly, this is program level, but nevertheless, the expectation at that program level was it's going to be a 4-track system. And in fact, when you look at the 2012 EIR, they explicitly said, well, we're going to look at another different alternative than what's been looked at in the 2008 or the 2010 EIRs. We're going to look at a 2-track system, which is essentially acknowledging the fact that up until now there has not been a 2-track system. Up until now, it's been a 4-track system. That's been the expectation, a 4-track system. We're now looking at something that would change that expectation. We're looking at a 2-track system. And that was added in the 2012 EIR, long after the voters had approved Prop 1A. So that's why I think that it basically is more than just an example of a possibility. It's actually saying this is what we're expecting to do.
But that's where I'm having some difficulty, which is even your phrasing is that's what we're expecting to do. Reflects at least a margin of change.
It says, if we're going to do something different, we'll have to come back and revisit this. And then that's what they did in 2012. Because essentially they certified an EIR in 2008 that says this is what we're going to do. We're going to do a 4-track system. They couldn't have done a blended system under the 2008 EIR without modification. It wasn't one of the alternatives they analyzed. It's not there. They couldn't have done it because it wasn't analyzed. It wasn't part of the project. It wasn't even an alternative to the project. They had to go back and reopen the EIR in order to add the 2-track blended system. So it could not have been something the voters expected to be built because, again, the voters are presumed to understand the law in which they're voting. And the law under CEQA says this is a final EIR, this is what you're approved, this is what's being built. If they want to change this to do an alternative that wasn't discussed, they're going to have to reopen.
All right, let me hear from Ms. O'Grady. Ms. O'Grady, do you have a response?
Yes, Your Honor. The record shows that the blended system is consistent with the Bond Act. And indeed, the Court of Appeal in this case quoted 2704.06 in its decision of what could be spent using Prop 1A funds. Environmental studies here doesn't say project-level environmental studies and no further programmatic studies. It says as subsequently modified, as the EIRs are subsequently modified. And they were modified in 2012, and no one is arguing. And by the way, there's a bit of irony that 3 years ago, Mr. Flashman was arguing that the EIR should study the blended system, and now he's saying they're inconsistent. But it's undisputed that the 2012 EIRs disclosed blended system, and even the 2008 EIRs indicate that there may be places where new separate HST infrastructure would be infeasible, shared track and operations.
I'm sorry, one more time. Infrastructure
would be infeasible. Shared track operations would use improved rail structure and electric propulsion. And that's the document number H7.011968. So I fundamentally disagree that somehow 2704.06 refers only to project-level studies. There's nothing in here that says that, nor is there anything that indicates that the voters were, back in 2008, were intimately familiar with the diagrams in the programmatic EIRs. This court has already said that the Bond Act only governs bond funds, and 2704 specifically refers to a measure to initiate construction pursuant to that section. So the idea that somehow 2704.04 relates to anything that gets built as opposed to what gets built with bond funds is just not supported by the statutory language. The court's supposed to read provisions harmoniously, and I think if you read 2704.04A and 2704.06, it's clear that modifications to the system were anticipated and do not violate the Bond Act.
Would you have inquired, though, if the 06 language was in the 04 subsection?
It would have, in a perfect world, yes.
How should the court basically read that difference?
Well, typically, 06 says what you can spend bond funds on. And if you can spend bond funds on, and so it's obviously more specific than the general legislative intent. So I think you have to read them together. It would be ironic that you could spend bond funds on something that is more expansive than your legislative intent provision. You might expect it at any rate. But even if you were to accept that, and the EIR is a very long document. It has illustrations of a lot of things.
I recall.
And of course, the 2012 EIR specifically says that the blended system is going to be deferred to a project-level report study, which is consistent with the whole tiering process as we discussed in our brief. And I'm not going to repeat everything in the brief, which is at pages 8 to 12, but there was a decision that this is a project-level type decision, and therefore it is consistent with the statutory language. Our brief talked about how consistent with means compatibility, and we've cited cases for that authority. They haven't cited any cases or even a definition other than their own for what consistent with is. We think that they've simply not shown that a blended system will prevent compliance with the Bond Act.
Mr. Fleishman?
Your Honor, a couple of things about this. One is in terms of the 2012 EIR, it is true that the language in 2704.06 says further additional environmental studies. But you have to recognize what was the position, what was essentially going on at the time when the legislature approved this, because when you're looking at statutory intent, you have to look at not just what's in the statute, but you have to look at what was the circumstances, what was being intended, what was the purpose being accomplished by this statute. And when when that section was written, the 2008 EIR had been approved, there had not yet been a court challenge to that EIR. That court challenge was not filed until August 9th, which was after the Senate had already given final approval to Prop 1A. So it was already a done deal when the challenge to the EIR was filed. And certainly no one had an expectation at that point that the EIR was going to be overturned and there was going to have to be a new set of program EIRs. The expectation of the legislature in writing Prop 1A and in writing 2704.06 was when they talked about additional environmental studies, they were expecting what we're talking about is project level studies. And that fits with the intent. And as I explained, it fits with the idea that you needed to add details, which is why they said you've also got to look at these additional environmental studies in terms of understanding what can be paid for with Prop 1A funds. It was not with the expectation that there was going to be a reopening of the program EIR. That wasn't the purpose, and that wasn't the understanding of the legislature when it approved 2704.06. Yes, in theory, I mean, if you just look at the language, then you'd say, oh, well, this is an additional environmental study, and therefore it fits. But if you look in the two sections and you ask about, does this make sense? Then, as she points out, no, it doesn't make sense that you would have a section that says you can only build something that's compatible, something that's consistent with the 2004 and 2008 EIRs, but you can use bond funds for something that's not consistent with the 2004 and 2008 EIRs. That would be kind of...
But that is the key question. How broadly should the word consistent with be read?
Well, I think, again, when you're thinking about something that's put before the voters, you start with the dictionary definition. And the dictionary definition is not the definition that is used in terms of talking about consistency as applied to general plans, because that's a very specific case where essentially the courts and the legislature have made clear that there's a tremendous deference to a city or county in interpreting its general plan and deciding what's consistent with it. That's different than when you're asking about an agency deciding about whether something is consistent with the statute that it didn't write, but the legislature wrote and the voters approved.
But we're also talking about a huge project, multi-billion-dollar
We are.
state. It's going to cover the entire state. There has to be at least some leeway, don't you think?
And that leeway is provided by the fact that it's program EIR. And so as long as you're within the bounds of that program EIR, you're golden. You've got the go-ahead to do anything that's consistent, that fits within what those two EIRs authorize.
So let me go backwards a little bit. We talked earlier about this diagram.
Right.
And we talked about the fact this is the assumption of what the track alignments would look like. And we're talking about the statute, which talks about consistent. So we have consistent with, and we have assumptions with regard to alignment. How does the court basically read those two things together?
Well, I think that the proof of...
And the reason I asked the question, I apologize for interrupting, is because it seems like the combination of those things provides for a fair amount of margin.
It does, but again, CEQA itself sets some limits on what you can do under an EIR. And CEQA says, you can do something that's described as an alternative to the project. You don't have to do the project. You can look at an alternative. You can look at something closely related to one of the alternatives you did look at. So you could look at a Pacheco alignment. You could look at an Altamont alignment. You could look at maybe even, and in fact there were a whole bunch, as you're aware, of different alternatives that fit kind of squiggled between those two, as an Altamont plus Pacheco or various permutations of Altamont and Pacheco. And all of those would have been permissible under the 2008 EIR, because they were all things that fit within what the 2008 EIR approved. But the proof of the pudding is the fact that in the 2012 EIR, they had to put in a new alternative for the blended system. They did not have anything from the 2008 EIR that covered that. They couldn't build a blended system under the 2008 EIR. They had to add another alternative. Now, as to the argument that in the EIR itself, it says this is the preferred alternative, is still 4-track. But it left open the option of a 2-track blended system. It was only when the authority board certified that EIR and made a decision that says, we're going with the blended system. But they didn't do it on the basis that the 4-track system was infeasible. They did it because they felt that for various reasons the 2-track system was preferable. So it doesn't fit under that contingency of when a 4-track system is infeasible, you can do 2-track. Never has anybody made a finding that a 4-track system up the peninsula is infeasible.
Is there anything you want to add?
Yes, I want to add just a couple of things. The legislature has dictated a blended system on the peninsula. So it may not be in the EIR, but a 4-track system, at least currently, in the peninsula is infeasible. I've heard a lot of speculation about what the legislature had in mind when they enacted this, but the fact that an EIR had just issued, I doubt if it shocked anyone that a lawsuit ensued after the 2008 EIR. It's much more logical that they presume that the litigation that seems to permeate this entire project would continue. I just note that there's no citation in their brief for a dictionary definition of consistent. We have cited cases that are pretty clear about that. I did want to move on, if this is within the range of this issue, about the legislature's ability to do what it did. Because in Section 2704.06, the legislature was delegated authority to set criteria, and certainly they did that. And we briefed in our brief the fact that the legislature was empowered to amend this bond act. So if it is a departure, I don't think it is, we believe it complies, but if it were a departure, it would be an authorized legislative amendment. It's not a substantial change in the project that would constitute an effective repeal of the bond act. And that's the standard for legislative amendments to bond acts that are proposed and enacted by the legislature and approved by the voters. This is a small piece of a very large system. It's saving $30 billion to go with the blended system, which should be in the interest of the taxpayers and the voters and everyone, and it's certainly within the legislative authority to do that.
I'm sure Mr. Flashman would like to respond to that.
Yes, indeed. By the way, we did cite to the Merriam-Webster Online Dictionary in terms of the definitions, and we quote from that in terms of it basically says what the dictionary definition of consistent says, that the two things are in agreement. That's, essentially saying, you've got A, you've got B, these are in agreement, and then we discuss some examples of when two things, what's the difference between compatible and consistent, and they are different. And I think that the briefs lay that out, that why there's a difference between compatible and consistent is more stringent than compatible. Now, in terms of what the legislature did, when it basically ordered that there be only a blended system, the legislature cannot do something that is not, that essentially acts to repeal part of the bond measure. If the bond measure says you've got to build it in accordance with the 2005 and 2008 EIRs, and if that means you've got to build a 4-track system up the peninsula, the legislature did not have the authority to say we're changing it to a 2-track system. And I would submit that when the voters approved Prop 1A and approved the system that's described in the 2005 and 2008 EIRs, part of the reason why they approved it is they said, we know what we're getting. We're getting what's described in these two EIRs. We don't have to worry about it getting changed and pulled out from under our feet. We don't have to be worrying about buying a pig in a poke. We've got something that's a defined quantity. Maybe not precisely defined, but defined well enough so that we understand in general what we're getting.
Let me interrupt, but aren't we back to the discussion we've already had? Doesn't this all boil down to how one interprets 04 and 06? If in fact the court were to interpret 04 and 06 in the way that you're advocating, then in fact the legislature would not have acted consistently with the proposition. If the court was to agree with Ms. O'Grady, that in fact 04 and 06 can be read in a manner that allows for the modifications to the EIR, then the legislature did act consistently.
Well, I think part of the question is why is there different language in 04 and 06? And I think Ms. O'Grady's explanation of why there's different language is really unsatisfying. Because again, the canons of statutory interpretation says if you use language, one set of language in one place of the statute and a different set in another place, the presumption is you meant something different. You wouldn't use different language in two places if you meant the same thing. And again, as I explained, the context of those two sections explains why there's that difference, because one of them is specifically about spending the bond funds, the other is in general providing the statutory intent in enacting the statute and describing what the system is that's going to be built with these bond funds. I mean, the other thing that really can be used to distinguish the blended system from the 4-track system that's in the 2004, 2005, and 2008 EIRs is what does 2704.09 say about the blended system? What does 2704.09 require, and does the blended system meet the requirements of 2704.09? Because if it doesn't meet the requirements of 2704.09, that's presumptive evidence that that's not what the voters intended.
Well, we're going to get there.
Okay, but my point is that ties in here, and that's why we brought it into the brief. It was not from the standpoint of this being an independent claim. It's basically saying this ties in with why the voters would not have been expecting a blended system, because the blended system doesn't meet the requirements.
Anything else on this issue? I think we covered it.
Nothing further.
All right, let's move on to the second question before that.
Okay. So the second question is submittal of a funding plan pursuant to 2704.08 a prerequisite to claims of noncompliance for either A, the entire San Francisco to Los Angeles line, or B, the San Francisco to San Jose segment? And maybe tied in with that, is a challenge to A and or B currently a right for review? Well, it gets us back to the question about what exactly is the bond measure about. Is this simply about authorizing bonds and saying how those bonds can be used, or is this a broader measure than that? And I think the answer can be found both in 2704.04A and in 2704.09, because neither of those talks about spending the bond funds. Whereas 2704.06 does specifically say, and likewise 2704.08, they both say these are restrictions on the use of bond funds. You don't find that language in either 2704.04A or in 2704.09. So those were more general. They were intended to have a different purpose. They were intended to discuss the system as a whole, not just how you use the bond funds. And consequently, whether there's been a final authorization for the use of bond funds or not is irrelevant to the consistency with the requirements of those two sections, 2704.04A and 2704.09. They're not about use of the bond funds. They're about the system itself, whether it's used bond funds or whether it's using other funds. And of course, there are other parts of the bond measure of Prop 1A that talk about other funds. There's a requirement that the authority get other funds. There's a requirement that no more than half of any usable segment or part of the system can be built with bond funds. But there's no requirement that any part of the system has to use bond funds. You could build a whole usable segment and use no bond funds at all if you had other funding sources. And by their construction, they could build anything they want as long as they weren't using bond funds. They could build a route up to Arcata if they weren't using bond funds. And I don't think that was the legislature's intent or the voters' intent in enacting Prop 1A.
Is that right?
The system that the authority has spent much effort planning is completely consistent with the Bond Act. I want to address he's kind of moved two issues together, but the issue of whether the Bond Act restricts anything that could be constructed, any high-scale system that could be constructed. And we discussed in our brief at page 29 to 31, but I just want to go over it really briefly. Just, I think it's been resolved by this court and by the Court of Appeal, which is back in 2013, petitioners asked this court to set aside the appropriation and to prevent the expenditure of federal money. They didn't make the argument that they're making now, but they made that argument, and the court held that the Bond Act did not affect the appropriation power of the legislature. And the Court of Appeal affirmed that point. And I believe that's been resolved. That issue has been resolved. Prop 1A doesn't restrict the legislature's plenary power to appropriate funds. And the Rail Act authorizes construction of a system, high-speed rail system, independent of the Bond Act, on either the appropriation by the legislature or a voter approval of a plan. So the notion that a Bond Act that was just to jumpstart the system is limiting forever what would be built in California as a high-speed rail system is simply contrary to what the Court of Appeal found. Nothing in the Bond Act purports to restrict the legislature's right to appropriate other funds for the Bond Act. And it is the legislature who has the ability and has determined what the authority can use those funds for. It's not, the legislature has not given the authority a blank check. On the contrary, the legislature has required, business plans and in their appropriations they require very specific reports. So this is not a blank check that the authority, if they have funds, can build anything they want. It is under the control of the legislature, which has plenary power to appropriate funds for the construction of a high-speed rail system. And this all goes to how unright this is. The petitioners made the same argument in the Court of Appeal that the project had morphed into something that didn't comply with the Bond Act. And the Court of Appeal was very clear that because there was no final funding plan, it was simply premature to determine whether the authority's design would violate the Bond Act. And nothing has changed. That is the holding of the Court of Appeal, and we believe that is controlling here.
Do you think 2704.76 changes anything? 557?
Well,
and the reason I asked the question is, as we talked previously, and as the court tried to indicate in its questions with the preparatory paragraph, the key question for this court is whether or not the authority has done something or something has occurred that precludes compliance with Prop 1A. And so part of the question here is, do you think that a legislatively mandated blended system in the Bay Area is something that could preclude compliance with Prop 1A?
the answer is, Your Honor, no. And the record that we've gone into has shown that even with the blended system, the authority is in compliance with the requirements of the Bond Act. In terms of rightness, in terms of exactly what's going to get built, that isn't right. But the facial, whether the Bond Act is facially valid, whether SB 557 is facially valid, it is. And everything that the authority has done has been to design, and we have a voluminous record, has been designed to meet the requirements of the Bond Act. There is no funding plan for the peninsula at this time, and so the design decisions aren't final. There is no funding plan for the only other area that petitioners identified as problematic, which is in the Tehachapi's. So it's simply too early to tell, to draw the conclusion that the authority has made, that there is a fatal flaw in the authority's plan.
But you would argue then, probably in some way, that a funding plan is a prerequisite. In fact, as a result of a lack of a funding plan at this point in time, these are premature claims. Wouldn't you?
Yes, a funding plan is prerequisite to determining whether the system complies with the Bond Act.
And when I hear you argue, Mr. Fleischman, is that it's not a prerequisite because this is not simply a bond act. It's more than a bond act.
That's correct. That essentially what the legislature was doing and what the voters were doing was not only approving bonds, but approving the general understanding of what the system was that was going to be built, regardless of the funding source. I think it's very important to realize in 2704.09 that it talks about the system to be built pursuant to this chapter, not the system to be built using bond funds. If they had wanted to say the system using bond funds, they could and would have used that language, but they used a much more broad language. They used language saying pursuant to this chapter, which covers more than just bond funds. It covers outside funds that the bond measure says the authority has defined. And it's basically saying, we're talking about a system that's going to be built by a combination of funds, and these are the requirements for that system, not just its bond funds. And to the extent that the Court of Appeal might have made an argument that, oh, you need to get a second funding plan before anything is right, that went beyond what was before it. What was before it was a challenge under 2704.08c. That was what we put before the Court of Appeal. And that was what it decided. And it says that challenge is premature because it's not going to be right until there's a second funding plan under 2704.08d. And we are quite clear and we understand that and we agree. We aren't trying to challenge the use of bond funds to build anything because bond funds aren't yet being used to build anything. There is no second funding plan for anything, so bond funds are out of the picture here. But the Court of Appeal was not looking at 2704.09, and it was not looking at 2704.04a. It was looking at 2704.08. If it said something beyond that, that was dicta, and is not binding on this Court or anybody.
Any other comments?
Just very briefly, the Court of Appeal has held and is well settled that any limitation on the legislature's ability to appropriate funds has to be very express and unambiguous. And there's not a word in this Bond Act that suggests that. The idea that the legislature would draft legislation for the voters that would constrain the legislature's own appropriation power is not logical. And nothing in the voter pamphlet indicates, the official voters information pamphlet indicates this is anything other than a bond act that provides funds to partially construct a high-speed rail.
All right. Last word, Mr. Fleischman, on this issue?
Yes, Your Honor. A couple of things. One is, basically, defendants are arguing that the public utilities code sections that established the high-speed rail authority and gave it a fairly plenary authority to build a high-speed rail system takes precedence over the Bond Act. Well, that's wrong for two reasons. One is when you have two acts and one is enacted after the other, it's presumed that the last enacted act governs if there's any conflict between the two. Secondly, the Prop 1A was not simply legislation. It was a bond act that was put before and approved by the voters. And under the Constitution, that locks that in. And under the Constitution, you can't change that by just going back to the legislature. You have to basically say, and in terms of well, it doesn't say anything about the legislature can't do anything to change this bond act. It didn't need to say anything about that. The Constitution says that. The Constitution says when the voters enact the bond measure, it locks it in. You can't substantially change that measure without going back to the voters, because that would violate the contract between the government and the voters. And there's lots of case law. Farrell is one that first comes to mind, but there's lots of case law that says that when you put something before the voters and they approve it, the legislature loses its ability to change that unless the measure specifically allows the legislature to change that. And again, the Shaw case, Shaw versus People ex rel Chang, that case very clearly shows that when something is put on the ballot and provides for ways in which the legislature can change it, the legislature can change it as long as it's consistent with what the ballot measure said. If the legislature tries to do something that the ballot measure didn't authorize and didn't allow it to be changed, the legislature cannot do that. And so what the 557 tried to do was something that was not allowed by Prop 1A, and consequently it's invalid.
All right. Anything you want to add, Ms. O'Leary?
I just wanted to note that Section 2704.06 specifically says that the bond funds can be spent subject to those conditions and criteria that the legislature may provide by statute.
All right, thank you. Let's move on to question number 3.
Okay. So